All right. Hi, good afternoon. I am Judge Echo Hudson, and I preside over Montgomery County Court at Law Number 4, and I am also a collaborative council member for the JCMH. It is my absolute pleasure to introduce this breakout session and our speakers this afternoon. This session is called Navigating Mental Health and Intellectual and Developmental Disabilities in Juvenile Court. This panel of judges, attorneys, and mental health experts will walk our attendees through real case fact patterns while identifying the points at which a child's potential mental health or IDD needs could be identified, the points at which the child could be diverted, and the appropriate services and dispositions that could be ordered. As to our panelists, Judge Cyndi Porter Gore is the presiding judge for the Allen Municipal Court and is the JCMH commissioner. Judge Cynthia Wheless is the presiding judge of the 417th District Court in Collin County and is also a JCMH commissioner. Molly Davis is the director of operations for the Texas JCMH, and Lynn Hadnot is the director of Collin County Juvenile Probation Services. Please welcome to our speakers.
Well, hello and good afternoon, everybody. We thought that we would walk you through a case study rather than just rattle off a bunch of statutes at you. Y'all can do that at home, but we've got some really great experts from the Collin County area today, so why not take advantage of them? Judge Wheless is going to act as our judge today. Judge Gore is going to act as our defense attorney, and Mr. Hadnot is going to act as all of the positions at Juvenile Services, so we're going to give him a workout. All right. So our case study is about a 14-year-old girl named Brianna. If you sat through the previous presentation, great, because it was all about what happens to girls in the juvenile justice system, and we happen to have a girl as the subject of our case today. So Brianna gets referred in on October 1st for injury to an elderly person. She lives with her elderly grandparents. Her grandma woke her up for school that morning, and Brianna refused to get out of bed. Her grandfather yanked the blankets from the bed, and a loud verbal argument began between Brianna and her grandparents. She refused to get ready for school. Her grandparents insisted. Her grandfather grabbed her by the ankle and tried to move her out of the bed. That made Brianna angry. She screamed and cried. Then she started throwing objects at her grandparents. Brianna threw a hard-soled shoe at her grandmother, which hit her grandmother in the eye and blackened it, causing pain as well. Brianna's grandfather was hit by a stuffed toy and a school textbook, which did not cause him any pain. He pinned Brianna's arms behind her back in a bear hug while the grandma called 911. Police responded quickly and found Brianna with her arms still pinned. She was screaming and crying at the time. The grandparents explained what happened, indicated that Brianna was out of control, so she was detained and booked into the juvenile detention center. This sounds like a case that many of you would be facing every day, right? At the detention center, Brianna follows instructions. She doesn't participate in the program that night. She's not interested in eating the dinner. She doesn't interact with the other youth during rec time. At bedtime, a detention officer does hear her say, "I want to die." So our first question is going to go to Mr. Hadnot, acting as Juvenile Services, but what assessments are you doing with this kid when she's coming into detention intake? What are you looking out for?
Thank you for your question, Molly, and thank you all for attending today. As you just stated, this is a regular day at the office for us in the world of juvenile justice. When that child is referred to us, obviously there are some statutory assessments and things that we have to do on the probation side of providing juvenile justice. That includes, number one, establishing probable cause to justify that it is a lawful arrest. Because while the facts of this case do substantiate a probable cause finding, there are cases where kids are referred to us for normal adolescent behavior that don't meet that threshold. And so we first got to begin there. Outside of that, we establish probable cause and we have to administer the initial screening instrument. And again, we talked earlier in one of our assessments about the difference between a screening tool versus an in-depth assessment. We begin with a preliminary screening tool and we administer what's called the Massachusetts Youth Screening Instrument, or the MACI-2. For those of you who are not familiar with that assessment or screening tool, it measures 6 subcategories to give us an immediate picture of what this child's needs may be for immediate service response. That includes measuring for anger and irritability, somatic complaints, thought disturbance, suicide ideation, depression, and anxiety. And again, there's thresholds in terms of how a child answers these 52 questions that will tell us if this child needs immediate services and supports put in place. So that's where we begin.
Does the MACI also count as a suicide screening?
It actually does. Thank you for that question. It does measure suicide ideation. And should we have a warning or a certain threshold met in terms of that assessment, we are required by law to make an additional referral for an actual more detailed assessment. And that has to be administered by a licensed clinician in mental health. And only that person at that level can make a determination to take that child off of watch. Because again, if the child meets that requirement, it also triggers additional safeguards that we must do in juvenile probation for a heightened level of supervision while that child is still in that state of need.
Got one more question about housing. We don't have facts about it right now, but can you tell us a little bit about how your department would decide where to house this child? And I guess what I wanted to know is there a difference in housing for kids whose behaviors match their chronological age? Is there different housing for kids whose behaviors may not, who have a different developmental age than their chronological age?
Molly, that's a great question. And it is something that is really important in terms of our assessment and decision-making when kids come into our care. We do obviously take a look at all of those complexities, but when we have a child, and again, outside of the evidence-based assessments, we also do some very important observational assessments. You know, when we're going through this assessment, we're paying attention to, you know, what is the child's ability to read the questions? Do they need additional assistance? We look at their functionality, and then we make a very informed decision about where are we going to be able to place this child in our care that's most appropriate. And again, we're not just looking at offense severity, we're looking at all of those different things. We look at the actual children within each of our respective pods to see where they're going to be the best fit to promote safety, security, and also a reasonable amount of comfort for that child until we can resolve their pending legal issue.
Okay. All right. Let's give us some more facts. So the next morning are detention hearings. At the detention hearings, Brianna cries quietly while the other kids have their cases heard. When it's her turn, she and her probation officer approach the bench, as do her grandparents. When the probation officer tells the judge what happened, Brianna hits her head against the judge's bench twice, hard, before her probation officer can stop her. Brianna's attorney, who met with her a few minutes before the hearing started, says that this is her first referral to the department, that detention has been traumatizing for Brianna, and that she wants to go home very badly. The grandparents tell the judge that they love Brianna, they don't want her to be in any trouble, but right now they can't provide suitable supervision for her. Brianna cries so hard, she cannot catch her breath when the judge asks if there's anything that she wants to say to the court. So again, to Mr. Hadnot, if the judge, we don't know this yet, but if the judge detains Brianna, what can you do to keep her safe now that we know that she has these behaviors?
There's a number of different things that we have to do, and they're critically important to promote safety for this child, as well as safety for our staff, because sometimes kids who have these needs, if they're not appropriately met, we can in turn escalate those children's behaviors where they lash out physically toward our staff members. So it begins with, again, collecting as much collateral information as possible. We go through extensive interviews with their caretakers, asking if there's any established history that we need to be aware of. And then obviously we want to make sure that we are being as observant as possible in terms of that child's just behaviors, their anxiety levels throughout each day. So those are the core things that we begin immediately doing.
If you were an intake probation officer, is there anything that's going through your mind right now about what you would recommend as services or interventions for this family, just knowing only these things so far?
Absolutely. Again, a more in-depth assessment to see exactly what the child's treatment needs are going to be. Oftentimes, we make a referral to our community-based treatment provider here in Collin County, that is LifePath, who we have a great working relationship with. Should the child's defense attorney consent, we would also see if they would concur with a in-depth psychological evaluation where we could really do a deep dive to see what the child's diagnoses may be, so we could work together to formulate the appropriate treatment plan.
Well, that's a great question for Judge Gore then. As the defense attorney, are you consenting to a psychological exam at this moment?
At this moment, probably not.
Tell us why.
And the reason why I wouldn't is, number one, I think in most jurisdictions across the state, that initial detention hearing, whether it's the court-appointed attorney for the day who's going to handle whether it's one child or 20 that are brought in the night before, or if I'm retained, because I used to do this a lot, usually I don't get that phone call till the morning of the hearing. Some courts start hearings at 8:30, some starting them at 1. So more than likely, I'm only going to have maybe 30 minutes to really meet with my client, get a copy of that initial affidavit, either for the detention to apprehend or the copy of the police report. The reason why I'm not going to consent initially is if my client is contesting and saying, I didn't do this, I don't want anybody asking her what happened other than me because it's attorney-client privileged. Often, one of the things I learned early on in my defense career was anytime you have a child brought in on an assaultive situation, often involving family, the first red flag that I'm looking for was my child the victim and defending herself. And the police erred on the assumption that, oh, the parents are all doing it right, this is a child that's the problem, or not. Now, these facts appear on the face that that's not a situation, but I've had many situations where when I go in to interview my client, even that first 30 minutes, it's like, you don't understand. This is what happened. Look at this. And they pull it up and show me claw marks or bruises, and these are fresh, and I'm getting my phone out, taking pictures. So until I have the discovery or have had time to truly talk with my client to the point to know that, okay, this isn't something that we're going to contest as to the facts of the case and take it to trial. I'm not going to consent for anybody to interview her about the facts, what happened. And part of that psychological evaluation is going to go into the facts of what led to her landing in detention.
And are you having any conversations with the grandparents at this time?
I am. I mean, because number one, my client wants to go home. She doesn't want to stay in detention. I've been in 17 years of juvenile defense. I never had a single kid that said, hey, leave me here. I like it. So I'm talking to the grandparents. I'm trying to figure out, because obviously this child's presenting with some depression, some serious anxiety. I'm trying to figure out in a nutshell, what am I dealing with? I mean, one of the things I'm going to ask my client, is how long have you felt like you wanted to die? Was it when you hit the detention doors last night? Or is this something that you've been battling for a long time? And so I want to talk to the grandparents to find out, what are we dealing with here? How many times has this escalated to this point that you felt it became physical and you felt that you had to call the police? Because if it's happening all the time, that's a different situation than last night was just different. Something happened, she snapped, and here's what happened. So I definitely want to get them locked into their story. Because if it's going to trial, I want to be able to say, didn't you tell me in detention this, and this? So yes, I am going to talk to the grandparents for many reasons.
Sure. And Judge Wheless, during the detention hearing, what questions do you have for the grandparents?
So numerous. On these facts, I'm thinking immediately about, this is her first referral to juvenile probation. She's not young for purposes of our court. And again, my constant refrain throughout juvenile justice is that these are not many adults. And the reason why the defense lawyer doesn't want the child to talk to our lovely, wonderful Dr. Lackey is because Our kids sing like canaries. I mean, they just get in there and they want to tell you. You didn't even ask, but they're just upping it. And so from that perspective, I'm so grateful to have such great attorneys on my list and that I can appoint. But this behavior in the courtroom is telling me that she is really reaching out for help. This is a cry for help. And I'm going to take her seriously because one of my best friend's daughters died by suicide at the age of 2 weeks past her 13th birthday. So this is an age group that's so impulsive. And I'm going to take every statement that she makes of self-harm, that she wants to die, as perhaps something we need to put her in a facility. And we're going to need the grandparents to do it because I don't have the authority. So many people are so happy to hear me say that, including Elise Ferguson in the back of the room. I thought I could order that. But at her age, I can only say that the parents have the authority to, I guess, willingly, voluntarily place their child in the private or public hospital at that age. A little bit older, I could do it. But.
So if the grandparents maybe had good insurance and maybe they had a plan or something, that might make a difference in whether this child is detained or released.
Exactly.
Okay.
Exactly.
And as the prosecutor, I'm not going to ask myself a question, but if I could wave a magic wand and change one thing in this world, it would be that every prosecutor who's assigned to juvenile court wants to be assigned to juvenile court.
Amen.
Prosecutors who are assigned to juvenile court, and not everybody gets, the choice in that. Smaller counties wear many hats when you're a prosecutor, but you have to understand family dynamics. You have to understand child development. You have to understand problems that happen within families, like golden child and scapegoating and the roles that some families can fall into and play. And we're seeing some of that with this family. I have been a teenager. I have teenagers in my life. What goes around comes around, but trying to yank a teenager out of bed in the morning is not going to get you a bright and shiny response. I can tell you that for sure. So as a prosecutor, if I'm reading this offense report, I'm already thinking that this family is having some problems communicating at home at a very minimum. There's also a bunch of other things I think that are going on, and I'm going to need some professionals to help me out. I'm also having to decide at this point in the next few days as the evidence is coming in and as I'm talking to the grandparents, am I going to file this case?
Yeah.
Sometimes it's the right thing to file this case. Sometimes it is not the right thing to file this case. Sometimes I'm going to have a diversion program that's going to work out that can help deal with violence in the home. And sometimes I am not, depending on where I am prosecuting in the state and what services and resources are available. I also have to decide what level I'm going to file this case at. A long, long time ago, way back when I started as a misdemeanor prosecutor, a mentor told me, if you can cut somebody a break, you should do it.
Nice.
I stand by that advice. It is getting harder and harder to be a prosecutor. Mm-hmm. There's more attention being paid from higher levels at prosecutorial decisions, and prosecutorial discretion is no longer what it used to be. So be careful out there. The prosecutor also has the duty to protect the public, and there is no crystal ball in this world that will be able to tell you that when you release somebody, even on conditions, even to a good and a functional home, that something bad isn't going to happen again in the future. So there's a lot of things to consider there. You can make an argument to file this case as a misdemeanor. The facts are there. You can also make the argument to file this case as a felony, depending on how bad the injuries are. Judge McCollum, I see that you have a question for us.
Would that decision change for the defense if the judge ordered that evaluation to be sealed and not released at that time? Because I think part of that concern becomes when the defense lawyer is ready to say, yes, I'm okay with the psychological evaluation. Now, for that BHA, we have a lag because now we've got to get it ordered and wait for the evaluator to get those results in. And everybody's ready to move, except now we put the evaluator on hurry, let's go mode. When if you seal it, in that moment, ready to go when you're ready to release it. So that's really sort of my question.
Can I repeat the question for the folks online?
Yes.
Okay, the question was long, a lot of good facts in it, but if I can paraphrase, would it make a difference, defense attorney, if the judge were to seal the evaluation that was done at this point in time?
No. Absolutely not.
No.
And here's why. Because that psychological might bring out other underlying facts that could be brought in during the punishment phase if we went to trial that the state may not have ever found out. I learned this the hard way doing certifications on cases, sending kids to district court. We submitted to all those psychologicals because I'm like, hey, if we can find something, I'm going to keep this kid from going straight to prison. Well, guess what? We didn't keep him from going straight to prison because he got certified, and then the adult prosecutors took all of that information and brought that in during punishment, which exponentially increased his prison sentence. So as a defense attorney, I'm a mom, okay? But when I walk into that detention center, I'm not wearing my mom hat. I'm not doing what I would want to do as a private citizen for my child. I have to protect their rights. And until we know that this is not going to be a contested matter, I have to do that. Now, an alternative to that could be, and this is going to depend on the jurisdiction, and luckily I practiced in a very friendly jurisdiction, I would file an ex parte motion to have a psychologist or psychiatrist appointed to do a private assessment tomorrow. And that way, that only came to me, and then I could disseminate that whenever it became correct. I completely agree with your position on it's delaying it, and this child clearly needs issues, and as an attorney, I need to know more, but I have to look at that long-term big picture because I don't have that crystal ball that I can't just say, oh, sure, go ahead. And Mr. Hadnot said that because I used to be the one going, nobody talks to my clients.
And I want to add a few thoughts to put a finer point on Judge Gore's point. This is a long process. If this case is going to trial, we're not the promptest, county in the world, and we're also probably within the average range of when cases go to trial. You have to take the long view for your client. It's not to rush up any cases or be dying on the altar of efficiency or quickness. We need to make sure the child gets their needs met. One of my lawyers put me in my place one time and said that an acquittal is much more therapeutic for his client than my fancy therapy programs. Yeah.
All right, let's find out a little bit more about Brianna. So Brianna is detained. At the probation intake meeting, the grandparents advised that Brianna has become more willful over the last 2 or 3 years, and she's now exhibiting some aggressive behavior when they try to get her to do things that she doesn't want to do, like going to church, doing her homework. She has slapped them, she has thrown objects at them, and until now they've been able to subdue her, but she's grown up and they have become frail. She's in the 6th grade and is in some special education classes for a generalized learning disability. She's taller and she is older than her classmates. She doesn't like going to school because the other kids make fun of her learning disability. And the teachers have noted that she mostly keeps to herself. Occasionally, she lashes out verbally when she's baited by her classmates and when she doesn't want to do something. She does not seem to have a friend group. She's behind in all of her classes. She does like art class, but that's when she can choose to work on her own projects by herself. Her biological parents have not been involved in many years. Her father was never around, and her mother has some serious addiction issues, including several criminal drug cases. The grandparents have had Brianna since a few months after she was born, when she tested positive for drugs in the hospital. So knowing this, Mr. Hadnot, in just the few minutes we've been here, how would you put together a case plan for this family? Do you have any recommendations so far?
Absolutely. I spoke earlier about some observational assessments we have to do, and I failed to mention that one of the things when we look at a probable cause report, that's usually a very short summation of the allegation. We already know that this child probably has gone through trauma before we even see the child at the door. There's a huge red flag. and that is grandparents.
Right.
So we already know that there's been something extremely traumatic that this child is being raised by grandparents. So that's number one. So we immediately start to, again, gather information about how do we, again, get the appropriate assessments, but also begin to build out a supervision plan and a treatment plan, and not just for the child, a support plan for the grandparents. We are seeing a more pervasive situation of parents, grandparents, especially foster parents, just completely wiping their hands and saying, I have done all I can and I'm walking away. So that engagement in terms of developing a plan begins with partnering with the grandparents, letting them know that, again, we're in it with you. We're going to be a support with you to walk through this process, get their input and buy-in about what's going on in the home, and work together to build that treatment and supervision plan. Because again, we deal with this every day, and oftentimes our parents and families, they're exhausted when they finally get to us. And so while it may be heartbreaking, I think it's important for us as practitioners to have some empathy to know that what these people have been dealing with on a day in and day out basis, to be empathetic and to listen to them, but then partner with them to say, you know what, we're going to go through this together. And then get their input, collaborate with your community stakeholders in terms of the assessment findings, and put a very robust plan in place to, number one, get that child out of detention. That's the initial treatment plan. Get that child in community-based services and have an infrastructure in place that can keep that child safe and out of jail while the defense lawyer builds up their defense for trial.
Are you thinking at this point something lower level, like anger management or anger replacement therapy, or are you thinking more like an intense program like cognitive behavioral or dialectical behavioral therapy?
That's a great question. DPT has truly been proven to be extremely effective.
Game changer.
And so those type of services would definitely be something we would start as early as possible with consent of everybody involved. Obviously, those records would not be able to be used to subject the child to a guilt finding or anything like that. And so we would want to work, again, collaboratively to put services in place, again, to keep the child out of detention. That's my primary focus at this point, based on what we have at this juncture. Services to support, supervision to promote community protection, but to help that child start moving forward, to keep them as shallow in the system as possible, because ultimately our department will make a recommendation to the DA's office as to what we want to do in terms of final resolution.
Yeah. And Judge Gore, as her defense attorney, what are you doing with the information about those school classes?
Yeah.
So the school information changes everything for me.
Yeah.
Because the first time I meet with this child, I know that she's not communicating well, but a lot of that I'm thinking, oh, it's the depression, or it's the trauma of coming to detention for the first time, because it's traumatic for them. But when I find out she's 14 and in the 6th grade, that's big, people.
Yeah.
That right there tells me, whoa, 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 whoa. Okay, and so now I want to make the assumption that this is like 95% of the cases that I handled with kids. Like they said, I used to always say my clients always had diarrhea of the mouth, because if one person asked, did you do it? They're like, oh yeah, and oh, by the way, did I tell you I did it? And did I tell you I did it? And so even if I can get one statement suppressed, the other 37 are probably going to come in. So I'm just going to assume, for sake of arguments, we're not contesting this, and now we're completely collaborating to figure out what's best for this child. So now I'm going to those grandparents and I'm saying, I need releases. I want all of the school testing records. I'm assuming probation's getting this, but in case they're not, it's my job to investigate this case. So I need that. What doctors has she seen? Has she had any testing independently? Does she see a therapist? And I'm getting releases from the grandparents for all of those records. And I'm now starting to collect all of that. I'm also talking to them and going, so is there any family members that might be able to take her right now? Does she have an aunt? Or here's something. Are you guys active in a church or a religious organization? I found many times when I had no family, but I had a family that was very active in a spiritual organization and environment, that often there were families in that organization that knew this family and was willing to step up and go, you know what? She can come stay, Brianna can come stay at our house. And here's the deal, our kids are all off at college now. And you tell me what the rules are and we're gonna follow it. And because I'm wanting to get her out of the detention center to see if we can then get her into some outpatient programs. So I'm gonna be talking to them long and hard about where's some other people. And sometimes I brought in those third parties, and if, I'd really vet them, but if they got how serious this was and I felt that they could adequately supervise her, because the last thing I want is for her to pick up new charges. It's better to stay in detention where we only have one charge
Big time.
than to come back out, pick up new charges with someone else.
Right.
Have you ever had a situation where the schools, because again, schools are tasked with tons and tons of things to do these days, but have you ever had a situation where a client of yours had a disability or some sort of condition that was not discovered by the school, and you had to go back and argue for accommodations or something?
Yes.
Many times. And there's been many times that I had to get the parents or the grandparents in this circumstance, we need to request a evaluation. And then they've got, I think it's 60 days to get that evaluation done and turn it. That's a long time in this situation, but we need to get that ball rolling. If they already had one, we need to have an updated ART. And I would go with the grandparents to that ART, not representing them, but just to be able to collect information and everything. But many times the school districts, she slipped through the cracks. They might have her diagnosed with one thing and they've completely missed that she has dysgraphia or something else.
I've done a couple. I've done a couple of things in our cases where these grandparents do seem to be on the surface acting in this child's best interest. However, if a guardian ad litem is needed, then we'll appoint a guardian ad litem to look into, is this really a safe place for her? Because honestly, it is not in any child's best interest to go back to a home where there's this kind of strife, if that is going to continue to happen. The other thing that we do in our county is that we appoint an educational guardian ad litem. And that educational expert is typically a lawyer who represents families in sort of a disability scenario at their ARD, at the child's ARD. So we have several lawyers in our county that are capable of doing that.
I think that's outstanding.
Molly, if I may,
sir.
The ARD meetings, I've learned over my career, are extremely important.
Yes.
And I don't mean to paint school districts with a broad brush, but oftentimes many of our families, they don't understand those processes, and whatever is said to them, they just accept it as gospel.
Yeah.
They don't push back. They don't have the confidence to ask questions. And so a number of kids that may fit this profile, we have made it a practice in our department that they're going to have some support when they go to those ARDs. I've actually personally been to a few myself. And it really changes just the dynamic and the collaboration and the openness of doing what needs to be done to really support these kids more appropriately.
That's amazing.
One additional caveat, just so that the practitioners know, the child has to be designated before the age of 18 to qualify for yes waiver of having a 70 or below IQ. I won't even bring up those psychologists that come up with a 71. That appears to be, I'll just save that for another day. But they have to have that designation or finding before the age of 18 to qualify for a whole host of services, because their parents, certainly in Brianna's condition where she has grandparents of my age, we're not going to survive our kids, so that the child is going to definitely live beyond our lifespan.
I'm so glad that you brought that up, because we're going to click to the next day. But at the 10-day detention hearing, so 10 business days have now passed while Brianna's in detention, Judge Gore has visited her twice, has 4 phone calls additionally before that 10-day detention hearing. I filed the felony level case. But it's clear that Brianna does not understand the court process like other 14-year-olds or like other 6th graders. So our next set of questions has to do with, what are your options at this point, Judge Gore?
Well, I can either advocate, and a lot of this is going to be negotiations with the prosecutor, because if we can go in a unified front, we're probably going to get what we want, because the judge will be like, well, both sides like this. But I'm going to be talking to them about, okay, do we go to competency route, or clearly we have some mental health, possibly IDD situations. Do we need to look at the diversion into that system to get her treatment and stay this other while we're trying to figure out exactly what we're dealing with? And there's pros and cons to both of those. But definitely fitness to proceed is now high on the radar. And if she has intellectual disabilities and severe mental health issues, she may never become fit to proceed. And if she does, then as a defense attorney, do I need to look into lack of responsibility? Because at the time that this all happened, because of those mental health and intellectual disabilities, she could not conform her behavior or even understand that what she was doing was wrong, which is a defense that we would then assert at a trial. So I'd be looking to have possibly both those assessments done at this early phase if we're going to go down the fitness to proceed.
Yeah, I agree with you. And as the prosecutor, I'll be honest, I did not know that as many times as I read it, that Chapter 55 of the Texas Family Code had a diversion option in it. But Subchapter B allows for kids who do have like a serious, they call it serious emotional disturbance, but they mean kids with serious mental health issues. And I believe that Brianna in our fact pattern here qualifies for that.
Same.
For her to be diverted from the juvenile justice system and into services that are available. I feel like this fact pattern is calling for that more than anything else. And I think that as a prosecutor, if I went and I talked to the grandparents, this is an offense that happened within the family. I'm going to guess right now that they want the best thing for her and that they might be amenable to this. And we might be able to, either through probation or maybe through private insurance, figure out some sort of intense services for her that would get her out of detention, out of the system, and where she actually needs to be. So that's one thing to think about. We only have 3 minutes left. I'm glad that this wasn't a Chapter 55 discussion, but let's just say the judge did file the motion to have her examined. She's detained till the exam can be performed, and she is not fit to proceed. But there's no reason given. That's because Brianna disengaged. She declined to participate for part of the exam. That happens. They are not fun. The examiner did have her school records, which estimated her IQ was lower than average, but again, gives a little range. Also gave an opinion that she meets the criteria for clinical depression, social anxiety, and ADHD. And so with the 2 minutes that we have left, what are we going to do with this child? Anyone can take this question.
Well, from a probation standpoint, looking at the totality of our referral history, the facts that we have before us, we're only making recommendations too. So that's one of the frustrations that I have. I don't get to be the decision maker on any of these decisions, but obviously we're completely vested. And in terms of negotiating with prosecutors, I'm glad that you're agreeable and see those things. But oftentimes when we don't have those agreements, I've been known personally to be pretty pushy and say, but you're only reading a police report. We are the ones that are in the trenches working with these children and these families. So please, take that into consideration in terms of our position. But we would be advocating to keep this kid as shallow in the system as possible and totally supportive of getting services in place and having this case completely diverted. That's where probation would be.
And as a defense attorney, one of the first calls that I always would make when I would get a call on a case was to the probation department. They know more about the dynamics of what's going on with that child and that family than anybody else in the system at the earliest point. So once I figure out my strategies, I'm going to be meeting with the assigned juvenile probation officer. I might even go out and meet with the detention officers that are in the pod with my child. So what are you seeing? Right. What's going on? What's your thoughts on this? Because they're potential witnesses in that fitness to proceed trial, because I have had cases where we send them off. They find that they're not fit to proceed. We do the 90-day commitment, and all of a sudden, poof, they're better. They send them back, and I'm like, Judge, it's worse now than it was 90 days ago. But we have a report saying they're fit to proceed. And so I'm bringing in those detention officers who've spent the last 2 weeks and maybe was with her 3 months ago to say, oh yeah, it's not good. But I'm also talking to probation because I know that the prosecutor's talking to probation. The probation's gonna make a recommendation to the court. And it's like, hey, if we all are kind of on the same page here, there's a much better chance that's what's going to happen. Brianna, I've had some Briannas. Judge Wheless appointed me to some Briannas. That 90 days didn't work, and then we had to look at a long-term commitment. But here's the concern you run into with this offense. Because it falls under the type of case that could be certified after 18.
Right.
What happens if she goes and she's in treatment and she turns 18 and the DA's office is not willing to dismiss that juvenile case and they seek certification because they couldn't proceed because she was unfit? And then suddenly somebody says, oh yeah, she's fit, and she's now in the adult system where the only options are adult probation or TDCJ. 5 years later.
I know we're over, but I just wanted to add one thing. This area of IQ is kind of a frustration for all of us where you're between 70 and 85. A lot of services are available though, because of just Judge Hervey's, I always say Justice Hervey, because of her work, we admit intellectual disability and developmental disability as well as mental illness into our mental health specialty court. So you might decide that all of this is unnecessary and she might, it's post-adjudication, so she would plead true and then go into our specialty court and then have her record sealed promptly. So that's another option.
We could unravel this case all day. Thank you all for your attention. There's some resources attached here, and we will be in the back hallway if y'all want to come chit-chat with us about your juvenile court. Thank you.
Thank you.